Okay, if you're just joining us, Judge Cannone came on the bench. They had a sidebar. They broke up the sidebar, and now it's each camp conferring, but nothing on the record in, well, it was obviously on the record with the court reporter, but we don't know the question yet. I assume we're waiting for the jury to come in, but we don't have a feel for what's going on. You can see Alan Jackson is writing something down, and Robert Alessi is, as characteristic, up and chatting with Yannetti, along with Karen Reed, who's been she has been front and center in her defense throughout this entire saga, and we're seeing that now. They seem to be drafting maybe with their proposed answer to the question. On the other side, Brennan doing the same, writing out what they believe should likely be the answer. Cannone, you could see, getting up off of her chair, getting ready to receive these proposed answers from each counsel. Brennan is still working on his. Jackson just gave the, well, now everybody's getting up. Again, no audio from the courtroom. Very interesting. Matt Mangione is with us. He's a former prosecutor and defense attorney in Pittsburgh, Pennsylvania. Matt, and I'll cut you off as soon as we get audio. What do you think's going on here?
Well, I think you're right, Ted. I think they're going through the question or the answer that each side would propose to that question. We don't know what the question is. Obviously, it's important to the jury. It'll give us some insight into what the jury is doing during this deliberation. But both sides are going to want to make sure that this answer that's proposed, is something that supports exactly what the prosecution or defense is trying to prove in this case.
You can see the bailiffs in the white shirts. It looks like the security has definitely increased once we get into verdict watch. In any case, it does increase, but you can see several security members, and now you're seeing the family members being escorted into their positions in the courtroom, the O'Keefe family in their normal spots, including John O'Keefe's mother, who has been a fixture, Peggy O'Keefe, at this trial and the first trial. The family has gone through hell and back and are here for justice. On the other side, the Reed family, of course, have supported their daughter, Karen, throughout. We got some audio.
To you now, so please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right, so I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay, and the Commonwealth?
That will suffice.
Okay, so it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
All right.
In the bench.
Please be seated. Court is in session.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finders.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment though regarding the time.
Do we have the indictments?
No.
I do not.
The indictments.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we could pull that up.
There's no time in the indictment.
There's no time?
It's just the date.
I don't expect that there's any time to be.
All right, so I'll say you have the evidence, and remember, you are the fact finders. or something to that effect. All right. Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
We raised the issue of preserving.
You're going to hate the whole thing, but I don't think it's going to. You're right. She just said she's going to. She's going to.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
So sure, you may practice.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
Okay, while Judge Cannone does that, reviews some items, let's slip in a break. We're going to pick it up right where we left off, though. You won't miss a thing. Back right after this. Stay with us.
Court, please. Jurors entering. Court is back in session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following. Motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors is sent out, maybe see.
Sure, why don't you come on over? I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, to the court, please. The jurors follow me. Jury is exited the courtroom. Please be seated.
Are you satisfied, Mr. Yannetti?
Yes, Your Honor.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back out in about 5 minutes.
Good. All right.
ID.
All right. All right, so we'll see everybody at 1:30. And
am on. Been watching all this stuff that's been going on with the jury having 3 questions, and I feel like I'm going to be bringing bad news, but I totally see this being a hung jury again. Before they started deliberations last week, they were fighting so hard, the defense was, to have certain things changed within the jury form. Mostly because there was, 6 or 7 different ways for them to convict her of being guilty on all this stuff. And then there was only one for not guilty. But there's so many different parts of it, which is why the hung jury happened in the first trial. And the jury actually in the first trial came back and said, here's what we thought she was guilty of. Everything else we thought not guilty. And there wasn't an option for them to choose that. So they actually were all 100% yes or no for these different guilty, not guilty things. But because it wasn't an option, it ended up being a hung jury. And I feel like that's what's happening again. I'm going to put probably a poll up in my chat. Everybody's been in and out of here. I think maybe they might come to a verdict today, but it's been taking a lot of time, a lot of days. Everyone's working, having things going on. So if you do come on, you see it, let me know what you're thinking. But I'm afraid that we're inching closer and closer to that. Although I have seen some people with this 3 different questions that were submitted, they think it's really bad and looking bad for the defense. I don't know. I don't necessarily get that feeling. But yeah, it definitely doesn't seem like that they're going to say, oh, she's not guilty on all of it. We'll see. I'm going to go ahead and put that poll up right now. I'm going to stay on. I'll have my mic muted. I'm working on my other computer, but I figure since I'm here, haven't been on video live anyway that much, so I'll stick around for a little bit. Okay, put the poll up. Yeah, and if you haven't been seeing any of the pictures, I had one up yesterday, but there's a lot of people outside the courthouse in support for Karen. A lot of people wearing pink. I did see some red shirts, but I believe that is to show support for Karen as well. A lot of people in Canton are on her side for this. Even the police sergeant who had worked there, I think, for almost 30 years. He's retired now. He's there and he's on Karen's side. And he said that there seems to be corruption going on in the police there. For him to be saying that is huge. He predicts that when this entire trial is done, that the FBI they've already started an investigation, that they're going to come in and continue it. It's going to be very interesting the next few months after this. Also, will the after this be after another trial? I mean, if it's a hung jury, they're definitely going to have another trial. John O'Keefe's family has said that they will keep going until she is found guilty. Now, if she gets the not guilty, I think the O'Keefe family will then move forward and sue her civilly. Just based on what John's brother has said, they aren't going to stop. They think it's 100% her fault, and they're looking for justice in that way. So it's going to be very interesting to see what happens with all of this. I'm putting myself on mute again so you don't have to listen to me typing on my other computer, but I'll probably be around for another 10-15 minutes. And yeah, like I said, I think we're close to a verdict. Maybe not today, but I think that there's a good chance. We have about 4.5 hours more that they can deliberate. So we'll be here for it. I'll be back in just a little bit. When I come back, if they're still on deliberation, which I think they will be, we're going to go ahead and watch last Friday the defense arguing with the judge to have some of the wording changed and information changed for jury deliberation, and the judge declining that. And then we'll go over what she did today that actually was a little bit what the defense was saying last week that she should do. She didn't do it a lot, she didn't change a lot, but it was for the better to help the jury understand. So we'll be going over some of that, see what we think on it all. The fact that she gave up anything and actually was willing to change it a little bit was big, because last week it was just a no, and that was that. All right, I'll be back in just a few. Okay. So the jury came back with another question right after they had submitted the 3 questions and got their answer back. So we're going to go ahead and watch what the judge has to say. They're still in deliberations. Okay. So the jury came back with another question. Getting it set up.
All right, so as council knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not the position for it. I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, which was literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
Your Honor, I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer that.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute.
Thank you.
Wow.
Unbelievable.
Holy mackerel.
Are we having deja vu right now? Is this Groundhog Day? Are we having the same trial over again?
Wow.
I see Vinnie Politan coming up. We got to check in and get your reaction to this, Vinnie. If not guilty on 2 charges, hung on 1. Are we hung on the same thing? Why can't the judge answer that?
I don't understand it. This is now insanity at this point. This is like we were back to ground zero where we were at the end of the last trial. All the controversy about the jury not understanding that they can return a verdict on a charge. They don't have to return a verdict on all 3. If they're hung on 1 and they've reached a verdict on 2, that is a verdict. To not answer the question, why don't you want the jury to know? It's hypothetical? Well, hypothetically, they don't know what they're doing. They don't understand because the instructions are not clear.
Vinny,
Alan
going back to
Jackson
court.
talking again.
Going back to court.
Objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
I don't allow the court to finish writing, but at this point, that is over our objection. I
understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
is
tell
that.
you to ignore anything, Your Honor.
All right, we are all set. So let's send this in, please.
All right.
We have to go back live.
She's unbelievable.
Wow. This isn't.
She is unbelievable. I greatly dislike her. Many of us do. What are your thoughts? You'll have to let me know what your thoughts are on that whole thing. Yeah, as they were saying, this is what happened the very first trial. And she's not being clear. The way she's wording it is definitely trying to give like a definitive answer. And all the defense attorney is saying is you're making it like this is the statement and that's that, when really it could be asked later and then you're willing to address it later. So it's a fair question. They're allowed to ask. She just can't answer it right now. But she will not change her wording. She will not leave that open, which means there's a very high chance that the jury is going to take that and say, oh, we can't ask this, like she's not allowed to answer. And that's exactly what happened in the first trial. And so we are slowly inching our way back to a hung jury, and I just don't get it. There's nothing legally against the law in any of this, with her just giving a little bit more in saying anything. She's not doing anything wrong with adding a couple more words saying for later or something. but she will not do it. Unbelievable. But as you probably were listening, we have court TV, all these anchors are here listening, and no one can understand why this judge is being this way. And I mean, goes into conspiracy theory a little bit, but is she a tainted judge? I mean, why would she be fighting so hard against Karen in some of these things? It just doesn't make sense. Unbelievable. Or maybe, if she's not in this whole conspiracy thing, maybe she doesn't like her and maybe she should have been recused. I don't know. But it's just very weird that she is not willing to take some extra steps to make sure that the jury understands certain things. She won't do it. I'm putting myself back on mute. They are obviously still deliberating. We're going to be here. They should be able to go to 5:30. It was 5:30 on Friday, but yesterday they seemed to wrap it up at 5. So we'll see what they do today, but we're staying on. I feel like we're getting closer to a possible verdict. I would imagine that if it doesn't come today, that it will probably be tomorrow. So I'm here, just muted. Crazy. It's a crazy day. All right, so I talked about a little bit ago about the sergeant who was the Canton PD sergeant for a very long time. He is now retired. We're going to go ahead and watch his interview with Billy Bush that really sheds some light onto what people are thinking. Conspiracy theory? Maybe not. Maybe some of it, all of it is true. Certainly he thinks so, which is a big sign. So I'm going to go ahead and play it while we sit here and they keep deliberating.
I've been clear about this. In my opinion, I think she is innocent. The injuries that he sustained, John O'Keefe sustained to his head, face, and arms, say dog bite and physical altercation. The injuries he did not sustain to any part of his body below the chin conclude for me that a car was never involved. But witnesses, they get paid and you get what you pay for on both sides. Back by popular demand. His last chat with us garnered more than 1 million views, so you could call him a ratings machine. Retired Canton Police Sergeant Peter Murphy. He served the Canton Mass PD for 30 years. He knows the playing field. Jesus, Peter, what have you been doing? You got a trainer or something? You look unbelievable. You look...
Can you hear me all right?
I can hear you great, baby. What have you been doing? You've been working out?
Really great to see you. I was trying to think, how many weeks ago was it I was on, or months ago? Do you remember approximately the date?
I don't know, but everybody's been watching it and talking about it. And since then, you've been on some kind of workout program or something, because you look very, very fit. I'm going to say that.
Well, believe it or not, thank you. As part of the movement group, there's a couple of people that are very, very into wheatgrass and ginger root and a bunch of things. As a matter of fact, honest to God, and as a matter of fact, Dylan Davies is on it. He's lost 5 pounds. His stuff is super tonic.
Next thing you know, you're going to be in a yoga Pilates class or something like that. What are you doing? You've lost your mind. Anyway, you look good. It's all working. We're talking to Peter Murphy, 30 years, police sergeant, Canton PD. You were out front of the courthouse today. You were there at the trial. Paint the scene for me. What was it like outside of court?
I've been outside of that courthouse pretty much 5 out of 5 days a week. Since April of 23. Today was really, really exciting. We've been getting a lot of out-of-state visitors coming in from Utah. Somebody had a live stream going today, and the person jumped in from Iceland. Tell me, you've covered a lot of big cases in the past, Billy. This case right now, to me, is certainly one of the most significant ones I'll ever see in my lifetime. And obviously, OJ comes to mind.
No kidding.
It's just unbelievable.
It's amazing. Trial watchers, Peter, is a very interesting thing. It's how I met that woman, House in Habit. Jessica House in Habit. She's now gone full MAGA, but I met her at the Gwyneth Paltrow skiing trial in Park City, Utah. Remember that guy on the slopes that said, he accused Gwyneth Paltrow of coming down screaming like a gorilla, he said, down a mountain out of control, and whacked into him and took him down. He tried to get paid by Gwyneth Paltrow. Gwyneth won that one, but that's where I met her. And then you think of all the people that came for the Johnny.
So we watched the Gwyneth Paltrow one. If you were with me then, you've been here for a while. If not, it's a great trial. And what was really interesting about all of it is, as he said, she ended up winning, he lost, but she, at the end of the last day, got up and, cameras were turning off, people were leaving the courtroom. She got up, she walked over to him and said that she really is sorry for the things that he's dealing with, and that she hopes that things get better for him, and who knows what else. She wasn't mic'd, but it was a nice moment from her that I thought people would really appreciate.
Amber Heard trial, that turned into quite a scene. He would arrive every day playing music. These things are now venues, and people do, come together. So I've noticed the crowd get bigger at Karen. I'm interested in this from your perspective because of your time serving in the Canton PD. Are you getting heat from your fellow law enforcement community, your fellow cops? Are they mad at you?
Yeah, this heat's been on my back for a while. They actually warned me and cautioned me not to come to a couple of officers, former colleagues' funerals, that there was literally a target on my back. And lo and behold, they targeted me. I got jammed up, totally framed, Billy, for want of a better word. And that's I guess, verbiage you've heard before on the Karen case. And they set me up. There were no elements of the crime. And I am on a
What did they accuse you of?
kind of hold.
What they accuse you of? Framed you how?
So the police station at 1492 Washington Street is immediately adjacent to a church. When I say immediately adjacent, they share a property line. And we had a big rally back in September of 24, September, what was it, 14th, I believe. Huge rally on the front lawn of the police station, Billy. We had all the news stations. We had many of the content writers there. I happened to speak. And at the end, we all cleared. Nobody got served. There weren't any police officers around. Then on December 27th, two officers came up to me and said, Mr. Murphy, we're going to charge you with trespassing. You have to leave the property. There was nobody there. There was nobody from the church. I never got any paperwork. Never. I said, well, and I knew the Sarge. I said, Sarge, you must have some paperwork for me because I haven't seen it yet. He goes, oh, look, I'm not going to dispute it with you right now. Get off the property. Had to hire a lawyer, a couple of $1,000 possible bill ahead of me. And at the hearing with the magistrate, Billy, here's where it gets really dicey. In discovery, the lawyer said to the magistrate, sir, I don't see where the elements of this crime have been met against my client. And he said he hasn't been put on notice. He was never warned by the police or the property owner. And the comment was from the prosecutor of the police department, oh, that report isn't in the folder, but we have it back at the station or something along those lines. It's a supplemental report. And I said, well, I looked for discovery on this case 2 weeks ago on my own behalf. And now here my lawyer is. And nobody's got that supplemental report, which is the whole case, the whole kit and caboodle. I mean, if you're not put on notice, there is no trespassing.
Yeah, it's interesting. And that's it. They hit you for trespassing 2 weeks after the event, right? I mean, after the event, that's a.
No, I might have confused you. The major event that we had was back on September 14th, and allegedly that's when they put me on notice that I was no longer wanted on the property. But they didn't nail me until December 27th. However, I've learned from some sources that they only put the signs up, and this is the caveat, they only put the signs up, which when I say that the size of my laptop computer that I'm looking at, the week before in December, so sometime around December 20th, we had about a 5-inch snowfall, and the snowplow buried those two signs that were ground level. Nobody saw them, and they weren't visible. They weren't visible the day I pulled in, Billy.
You didn't know you weren't trespassing. Okay.
I didn't know there was nothing.
And who cares? You're standing on the front lawn. I mean, come on. It's okay. He's trespassing. And it's right in the middle of town. What is that sign behind you? I can't read it. I feel like I'm at the optometrist. I need to cover one of my eyes and say JKB with justice for Sandra, Karen, and John. Bring in the feds. Who's Sandra? I got Karen and John.
That's that Sandra Birchmore case that where she was deemed by Morrissey's office.
Oh, you can come back.
I'm coming back. She was deemed a suicide victim a year before the Karen Reed case, Billy.
Oh boy. All right, so the cops have... Look, the thing that's hard for people to understand, I think what's like... For me, and you served as a cop for 30 years. So, for me, it's hard. Like, I believe the best in people, right? It's hard to really wrap your head around the fact that so many people, could come together to defend, that thin blue line. That there would be such a thread, a through line with all this corruption, that so many people could come together and tell lies together. I mean, you've lived a little life. Wake us up to this. There is that kind of evil in the world.
I never, ever thought in my lifetime that I would have to stand in front of Superior Court or in front of the Canton Police Station, knowing what I know as far as the improprieties of what have been done to Karen Reed and the allegations that have been made, the non-investigation. I mean, I am humiliated. I'm embarrassed. And I am goddamn angry, Billy, about what's going on. I risked my life for 30 years, kissed my kids goodbye, and myself and all the many other good officers that are out there today and have retired, we deserve better than this. We shouldn't be getting slandered. This is going to be a mess when this comes out.
Yeah, I amen to that, and thank you for your service, Peter Murphy, longtime Canton PD sergeant, retired as a sergeant.
Yes, sir.
So,
Yes.
so Peter, both sides seem to have heavily relied on accident reconstruction this time. Are you surprised we never heard from Michael Proctor? He wasn't called during this trial, or either of the Bryans. Neither Brian Albert or Brian Higgins were called during the trial. They had starring roles the first time around. It really got down to sort of biomechanics and technical data. Did that surprise you? And was that smart, do you think, by the defense? Is that where it all lies?
I think after watching, this is my opinion, I think the defense probably looked at the totality of the circumstances and all the lies and on all the inconsistencies and knew nothing about the old famous adage, if you don't know the answer to the question, don't ask it. Well, they didn't know the answer to any of these questions because everybody that you just mentioned, for the most part, told the white lies or lied altogether. And they were probably afraid to bring these people in, not knowing what a cock and mammy story they're going to hear. So go with the hard, fast, physical data, science, physics. That doesn't lie. People lie. Evidence doesn't.
That's a good point. That's a really good point. Have you gotten a chance to meet Karen? And when she comes out of trial, she always, when she comes out of court, they throw some microphones in her face. She talks. Does she mingle with the people? Have you ever had a conversation with her? Does she know of your support and loyalty?
She does. She's very appreciative. We've talked in the past many times. She says hi to me when they drive by, when we're at the standout. She knows me. She says, hi, Peter. I say, hi, Karen. Good luck.
Oh my.
She's amazing. She even said to me the other day, she said, hi, Peter. She said, oh, you got a haircut. How did she know that?
Well, I noticed something too. I don't know. You look. I think you might. I'm noticing the juice cleanse. Anyway, it's interesting. I wonder. There's such a community here. It seems to me most people are on Karen's side. Is there a presence outside the court that is pro-police and anti-Karen? And how big is it?
No, I would say it's zero. And I would tell you that in all the standouts that we have done in Canton, Dedham, we have 100 strong sometimes in Dedham every Sunday. I would say it's 95% or better support for what we're doing and what our signs say: Free Karen Reed, Justice for John O'Keefe, etc. 95% or more. Horns, thumbs up in the air, favoritism toward our movement. Very seldom do we get a negative look or gesture from the hand.
Yeah.
From the other side. Very seldom. Very seldom.
You know what's amazing to me, Peter? I have to tell you, I keep coming back to this. I keep thinking about Peggy O'Keefe on the stand, mm-hmm. John O'Keefe's mother. And I ache for the woman and the pain that she's been through and the loss. You can see how just damn beat down she is. I mean, she lost her daughter, she lost her son-in-law, and then she loses her son. I mean, this is just, she's suffered incredible loss, and, to her husband as well. But I think of Peggy, she is so bought and paid for on behalf of the cops. There's no part of her that will entertain that anything else could have happened to her son other than that little Karen, who she doesn't like and never did, obviously, because of their interactions in the hospital. What is?
Does that sound familiar? That is literally what I was saying about a week or two ago, talking about John O'Keefe's mom. It is clear that she did not like Karen from the get-go. Even the day of him getting taken to the hospital, and Karen went to the hospital not only to be there for John, but her parents notified them that she needed to be held because they were afraid that she would hurt herself if something happened to John. But she walked in that day, the mom did, and ignored her, walked right around Karen, went to the nurse and said, "What is she doing here?" Not a normal reaction, especially since Karen was the last one that we know of that had talked with John. But we do know now that it seemingly he probably did go into the Alberts house. Who knows, all speculation, but it just was an odd moment, and I love that Billy Bush thinks the same way.
Doing here when she runs into Karen that morning at the hospital, when Karen went to pick up her stuff after she left the hospital, when she went to John's house to pick it up. They have icy interactions. She hates Karen. But the fact that she's heard everything, we're all rational people, and we're all sitting in the court, we're all in the jury of the court of public opinion, and we're hearing what we're hearing. Most people are like, absolutely, this woman didn't do it. And yet the mother is so far gone. Why do you think that? Is that how deep the police loyalty runs in Boston?
That's a very good question, and it's asked by so many people, that how can anyone, without even having any knowledge of the case, if you just came in and took a cursory look at the evidence of the autopsy pictures, etc., how could anyone ever think that a car hit him and that those aren't dog bites? And that's where the conversation should end, Billy. I don't know. Let me put it this way. I've never suffered the probably emotional trauma that both families are going through right now. And I can only say that it would probably be easier if she was sold a bill of goods by the other side, the non-Karen Reed supporters, and got closure immediately than to try to go through this turmoil. In other words, I guess what I'm saying is, in her mind, if it was easy to get closure on what happened and buy into that plan 100%, then, God bless her. I understand why she might be doing that, but that could be the only explanation I can offer.
Peggy is just, she's just stone-faced. I mean, I'm looking at Brian Albert, I'm looking at Brian Higgins, I'm thinking, do you guys have something you want to say to me? Because in the end, I mean, the closing arguments are going to, take place Friday, we believe. I think the jury's going to come back very quickly. It could be this Friday. I believe they're going to come back. I'm pretty confident Karen is going home, whether it's, hung jury or whether it's totally innocent. I'm guessing totally innocent across the board. And then what do they do? Are they going to go and try this thing a third time? Or is Peggy O'Keefe and maybe someone else going to say, why don't we take a break here and go find out who actually did this to John O'Keefe? If I'm a mother or father, I want to know what happened to my child.
Exactly, Billy. For me,
Peggy is not going to say that. All signs from her and John's brother said that they will not stop until there's justice and Karen will pay.
Your lips to God's ears. Find out who really did this. And my only comment to you on that theory is that I believe the feds are definitely coming in on this case, and I believe they are waiting to get everything they need, get all their targets lined up, and I believe they will come in. I believe they spent $500,000 on ARCA. They're not going to walk away from this case, Billy. They've spent a lot of hours and dollars on investigations. We know that. We know a lot of the people they've talked to that's come out in this trial.
You think the feds are going to investigate the MSP, the Massachusetts State Police, and the local police and all that? You think they're coming in?
I do. I think they might even come under the RICO Act, which is the Organized Crime Racketeering Act. And
but Trump is such a pro-law enforcement, pro-cop guy.
Correct.
I think I don't see him doing that. Do you? I mean, really?
My opinion only. I really see the feds.
Basically, everything's decided at the federal level by Donald Trump these days. There's no independent Department of Justice or FBI. They're all, extensions of his tentacles. So if he wants to, it will. If he doesn't want to, I mean, that's the world we live in.
I do think he's a law and order guy, for whatever that means. And I really think that he's got his sights on Massachusetts right now, and as probably does Leah Foley, who took Josh Levy's job.
Okay.
U.S. Attorney General.
All right. We're talking to Peter Murphy, 30 years, Canton PD, retired as a sergeant, and he is taken, you know what? We're looking at people these days who have the courage to step up and do the right thing. He is, he's one of them, but he's saying they're not one of, they're not me. And they're not, he's doing it for him and for the other cops that retired with honor and dignity. Now,
correct.
We got to go someplace. I feel like you and I know each other well enough now that we can approach this one last little area. It's a crazy rumor that's going around, but a lot of people are saying it. So you and I can talk about it because we're great friends here. But have you heard anything about this whole swinging thing, like the Bryans and the Jen McCabe's and all these people inside that party, that they're all a bunch of swingers?
In my opinion, I can conclude that that has been out there now for almost 2 years, and there's a lot of names that are floating around. I won't disclose them right now, but yes to your question.
Really?
No receipts. Billy,
No
my keys aren't in the bowl.
Yeah, there's something. My keys aren't in the bowl. There's keys in the bowl is one thing, and then they say if you see two Adirondack chairs in somebody's front lawn, it's a signal that we swing inside. And the other thing I heard was if somebody leaves their garage door a foot open, then that's a sign that hey, we swing in here. I mean, you're a
or an upside down pineapple. Put that into your journal. An upside down pineapple, Billy.
And that says we swing too? That's a fourth one?
That's what I've been told.
I mean, you're a cop. You've seen some crazy things back in.
All right. So yeah, pretty interesting that he had been with them for 30 years, police sergeant, and the entire police in the area have now turned their back on him, that he's not welcome to go to things, not even a funeral, that there were active threats in that community against him. Unbelievable. I mean, that just really makes them seem and sound guilty of the different things that they are being accused of. He is one of the people that say the FBI is probably going to come in. They're probably watching this right now unfold, and that he thinks they'll come in when this is over. When will it be over? Who knows? So obviously they had this conversation last week. Billy thought that the verdict would come back very quickly, even maybe Friday. Nope. We are now on Tuesday, so clearly not yet, but I do think that it could be today. And if it's not today, I think it will be tomorrow. Just a feeling. I feel like we're inching closer and closer, especially when you hear the different questions that the jury has been putting in. I think it's going to be soon, but man, do we look like we're going for another hung jury, and that would just be insane. As I said, I completely agree with Billy when it comes to the mom. She just seems to be, she's been through so much in life. So her looking miserable while she's there, of course, that's John's mom. Her daughter and her son-in-law died. There's so much heartache going on within that family that I think at this point they are just trying to grapple with all the loss, try to get some justice if they're able to. And so, yeah, all their eggs are in the Karen Reed basket, and that is not going to change. I had not heard about the swinger stuff, so I thought that was pretty funny. If any of you have, you'll have to leave comments and let me know. That's pretty wild. But hey, crazy things happen all the time. So, all right, I'm going to put myself back on mute. I'm still here working. They're still deliberating. I keep poking around to see if anybody else has any new information, but no. We have about 2 to 2.5 hours left of them being able to deliberate today. So I will be here just in case, ready to go. Otherwise, we will be back on in the morning. So, just a fun fact. I've been reading a lot about Karen Reed's parents because if you haven't noticed, they sit beside her or right behind her like every single day. They haven't missed a beat. They're very, very supportive of her. And I had come across an article that talked about how William and Janet Reed, they've been actively involved. They have mortgaged their home and are even using retirement savings to help fund her defense. That's how much they believe in her innocence and are trying to help her. Oh, they've even done some interviews, so maybe the plan will be tomorrow. If this goes on tomorrow, we'll watch some of the interviews because I haven't seen any of the interviews with her parents, but they have really stepped up. And it's just nice in general seeing parents care so much and stepping up to do what they can to help their kid. All right, putting myself back on mute. All right, we have not been following along with this trial that I'm about to talk about, but there was breaking news for it, so we're going to go ahead and put it on. Sorry, adding it so we can go ahead and watch. All right, here it is.
Follow the breaking news that's happening in Dedham, Massachusetts with the Karen Reed verdict watch. But we also have some breaking news and a verdict in another live trial that we've been following here on Court TV and CourtTV.com.
Yeah, Megan Jackson was on trial for plotting with her lover to kill her boyfriend. The verdict has just come in. Let's watch.
Indictment number 2021 GS 2601191. The state of South Carolina, County of Horry versus Megan Marie Jackson as to the charge of murder. We, the jury, by unanimous consent, find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
I let the record reflect that all jurors raise their right hand. Any opponent of the jury by the defense? No, sir. All right. Hi, ladies and gentlemen, I want to thank you for your service. I will conclude your duties as jurors in this case and for this term of court. And I want to thank you for your service. I know jury duty is not a fun thing to do, but it is an important thing to do and a vital thing to do. You have a 1-year disqualification from serving as jurors in state circuit court. You've got a 3-year exemption. I hope you don't exercise your exemption because we do need good jurors. And I want to thank you for your service.
All right, so yeah, like I said, we haven't watched that one. There was absolutely no reaction when guilty was said, so evidently it is not a surprise for her. If anyone has seen any of this jury and you think it's worth watching, let me know. After dealing with the Karen Reed stuff every single day, I just would like to go and watch some interesting ones that I haven't been able to. All right. I caved and I decided maybe I'll put on a couple of Karen Reed's different interviews that her parents gave. I found 2 right off the bat, so we'll go ahead and watch.
Parents say she and John O'Keefe became serious in 2019, right before the pandemic.
They just seem to be in a happy place, you know, yeah.
And spending a lot of time together?
Yes. Yes. Mm-hmm.
Vacations together.
Yep.
Going out together.
If the relationship had become toxic by January 2022, as prosecutors allege, it's not apparent from this snapshot in time. At C.F. McCarthy's in Canton, they laugh and embrace during a night of heavy drinking. According to police, Karen would back over John and leave him for dead in a snowstorm 2 hours later. Prosecutors say it happened outside the Canton home of another Boston cop named Brian Albert. Karen says she dropped John off there for a get-together. During your first discussions with Karen, did she believe she may have hit John?
No. She felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? This was in the hospital. Right? She says, I remember, all right, backing up and hitting something.
Police find damage to the passenger side taillight of Karen's Lexus LX 570. How the damage occurred is in dispute. The Reeds believe it happened when Karen backed out of John O'Keefe's driveway, hours after police say she hit him. Here's the video.
She backs up to go out and search for John O'Keefe. And that's how that vehicle was damaged.
In court documents, prosecutors say the video only shows Karen coming close to John's car, and no fragments or pieces of a broken taillight were discovered in John's driveway.
Look at it frame by frame. And you tell me whether or not the O'Keefe vehicle, the left rear wheel, does not jetson forward upon impact and return to its previous position.
Police did discover pieces of taillight where O'Keefe was allegedly hit, but the Reeds say it wasn't until after Karen's SUV was in the custody of law enforcement. State police reported towing the Lexus to the Canton police station at 5:30 p.m. Nathan Reed says daylight video from his dad's house shows the car was taken more than an hour before that.
They confiscate Karen's car at my parents' residence in North Dayton at 4:16 p.m. And somewhere in the neighborhood of 5:30, 5:45, Mass State Police CERT team comes back to the scene. They search the scene then with 2 feet of snow, and pieces of a tail lamp are found on top of the snow.
The Reeds also question John's injuries as seen in autopsy photos. They say John appears to have dog bites on his arm. The defense theory is that O'Keefe was beaten inside the Albert home and attacked by the Albert's German Shepherd. Brian Albert's attorney declined to comment.
Our investigators also have found multiple people who have been attacked by the dog. I think John O'Keefe entered that house, was sucker punched, a fight ensued, and he was overwhelmed.
Prosecutors call that theory a fanciful conspiracy. According to the Norfolk DA's office, 8 people inside the home and 3 more outside had testified that O'Keefe never entered. The office says GPS data from O'Keefe's phone backs that up. And the medical examiner who performed an autopsy on O'Keefe found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight. If the events happen the way Karen's attorneys say they did, how many people would have to be involved in the cover-up?
My sense is that there are a handful of people, influential people, who know what happened. And ultimately, all right, will resolve these issues. My daughter will be free. That's what I believe.
Are you confident of that as well?
Yes. Yep.
Is Karen
Yes.
that confident?
Yes. Yeah. We are.
The Norfolk County DA's office is now publicly pushing back.
All right. So that was the first one. That interview happened before the first trial. So if some of it seemed outdated, or if you thought the news was making all these comments that have been disproved or anything like that, it was before the trials. right, this is her dad going into court during this second trial.
How are you feeling?
Feeling great.
Any comment?
Any comment? Well, I wish I wasn't here, but this is what corruption is all about. Just look at the injuries. They don't correspond to being struck by any vehicle. I want justice for John O'Keefe, but that may come at a later day. It's all about the science. You heard Dr. La Posada, you heard the ACA witnesses, the scientists from ACA who are hired by the U.S. Attorney, the Department of Defense. Sorry, Department of Justice. Check that. And so, you know, this is the final stage for us. Just catch Attorney Jackson on his closing. Digest it all. Take it in. Because someday it could be your son or your daughter. God forbid. Thank you.
Thank you.
All right. So yeah, that definitely, let me get back over to the neutral screen. That definitely is just a little bit of the details of what he thinks is going on. I'm sure it's wearing on all of them. And I would like to say, oh, it's almost done and there will be an answer soon, and hopefully they can then go back and continue to see what they think happened to John O'Keefe. But if we're gonna have another hung jury, there will for sure be a trial number 3, and it will just keep going if that is really the path that it takes. Hopefully not. I was going over some of the polling that I put up in the live chat, and everyone so far is on separate pages, which is not a good sign, because that means the jury is probably everywhere and on different pages. And then not to mention that everything they have to sit there and go through, and they don't know some of the things. They don't know that they could find guilty in one thing but not guilty in other, and put it all like that. It's going to be a very interesting verdict. I'm going to put myself back on mute, but I'll be here in case something happens. All right, they're gathering again, so I'm gonna put this up.
Give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for court, please. There's following.
All right, they called it a day. It's just a few minutes past, or a few minutes till 4, so they're not even gonna go until 5. We will be back on here tomorrow, bright and early. I'm gonna see tonight if there's any more videos or things along the way through this case that maybe we can watch tomorrow while we wait. But hopefully tomorrow, I think they probably will come back and we will then find out if we're going to have a million more trials or if they happen to be saying guilty or not guilty. So, all right. Thank you so much for watching and I will see you tomorrow.